Hi, David. You're the court reporter, right?
Yes, sir. I'm sorry. I was trying to get off mute, but I had a couple of buttons I had to push first. Mr. Lundeen, do you happen to know if there's anybody else on the public speaker list than the four that were sent out this morning?
Um,
It was the two Kellys or the two Golds, Miss Padilla and Miss Kelly.
I imagine there'll be one speaker from every party that shows up. I don't have a speaker list.
All right. My understanding, just for your own information, is it's Peter Gould, Kelly Gould, Leslie Padilla with P&M, who I believe is corporate counsel, and Samantha Kelly, who in the last hearing at least was with Miller Stratford, but now has a P&M handle at the end of her email.
Yeah, I imagine there's going to be several more than that.
All right.
Did you get a longer sign-up list of just participants?
I have not, but if I could, it's probably too late to do anything about it now, but I'll need that, and I'll get
Okay.
with Leanne.
Yeah, I'll email Lori and tell her to send it to you.
Thank you.
Mr. Lee, what is your email address?
It's davidlee.cumbre, CUMBRE @gmail.com.
Thank you.
You bet.
Hello,
Hi, Judy.
how are you? Um, you know, I scheduled a call with someone from the Attorney General's office at 3:15. So, I'm not sure if I can make that other meeting at at 3.
Okay, I'll let Commissioner know. Judy,
Okay.
just so you're aware, we are live on YouTube.
Okay, all right. Yeah. It looks like we have 1, 2, 3, 4, 5. No. I'm not sure who 238492 is.
That's Zoe Lees from SPS.
All right. Well, just so everyone knows, I'm going to wait at least a few minutes after 1 to start, just to make sure that everyone has a chance to get on.
Judy, we didn't have a very thorough sign-up list for public comment, but I imagine a lot more people are gonna make public comment than was on the list. So for David Lee's ease, could you please ask everyone to just state who they're representing and state their full name?
Yes, that will work.
That's the message, man. Hello.
Hello, Commissioner. Judy's going to get things started here soon.
Oh, okay. Just seeing all the folks there, and was wondering why no one was talking.
Joan, this is the court reporter. Is that Joan Drake?
Hello. Yes, I'm going to start at 1:05 just to make sure that everybody who wanted to get on was able to.
Hi, David. Yes, this is Joan Drake. Thank you.
Thank you, Ms. Drake.
Sure.
Hi, everyone. This is Anastasia Stevens. I'm sorry I need to call in. Can you hear me?
Yes, we can hear you. Thank you. It's fine.
Okay. Never done this before, but I'm sitting in a parking lot.
You know, I'm sure many of us have had a similar experience, you know?
Except that exactly at 1 o'clock, the car next to me, which was an old Jeep, started turning on and running its engine. It left.
Right. So it's not an electric vehicle, right?
No.
All right. Well, it's just about that time. Well, good afternoon, everyone. I would like to go on the record for the public hearing in case number 20-00158 UT, entitled "In the Matter of a Commission Rulemaking Regarding NMPRC Rule 17.9.572 NMAC Renewable Energy for Electric Utilities." The commission issued an order of notice of proposed rulemaking on August 17th, 2022, and all of the state records requirements were followed by publishing in the Register and receiving initial comments after 30 days. We received comments from numerous participants, including, but not limited to, staff, El Paso Electric Company, Southwestern Public Service Company, Public Service Company of New Mexico, and New Mexico AREA. With that, I would like to introduce Commissioner Fishman, who is present and participating. And if he would like to run the public hearing, I will hand it to him. If he would like to designate me, I can proceed.
I am designating Miss Amer to run the meeting.
Thank you. And I was informed that the sign-up sheet was not complete. Someone is saying they cannot hear everyone. Zoe Lees. Well, hopefully, then I won't ask her to come on first. Who I would like to ask to speak first, and I hope I'm not putting you on the spot, staff, David Black and Alicia Leba Tercero filed comments, and I would appreciate a summary of their comments just as an introduction for everyone here. If you feel most comfortable just reading them, that would be fine too. But with that, I would hand it over to Alicia and David Black.
Thank you, Judy Amer. This is David Black for staff, and I'm going to turn it over to my client, Alicia Leba Tesero, the author of the comments.
Thank you.
Good afternoon, everyone. This is Alicia Leba Tercero, Economics Bureau Chief in the Utility Division of the Public Regulation Commission. I wasn't planning on going over all of my comments today. Staff did file written initial comments on the 14th, and we have seen the comments of other commenters in this case. And so I may have some changes to my comments, but I can try to go over some of the issues that I've addressed at this point. Do you want me, Judy, to go over each section?
Well, that would be good. Just briefly, as I said, if you feel more comfortable just reading them, that's fine. If you want to just summarize them, that's fine as well.
Sure. So with regard to the proposed subsection 17.9.572.7a regarding the definition of average annual levelized cost, staff maintains its position regarding this subsection of the proposed rule. Staff believes that it would be appropriate to define the term average annual levelized costs strictly for the purposes of determining the reasonable cost threshold, and staff supports the definition that is currently being put forth by the Commission in its proposed rule. And on the next section, paragraph 17.9.572.7 the definition of reasonable cost threshold. Staff again maintains its position regarding this paragraph in the proposed rule. Staff supports moving the language that was already included under the existing subsection 17.9.572.12a and appropriately placing this definitory language under the definition of reasonable cost threshold. Next, with regard to paragraph 17.9.572.10c3, this is on the DG recs. Staff continues to believe that this proposed paragraph is consistent with 62-16-4A of the REA. However, because several of the commenters find the proposed language to be confusing or ambiguous, staff believes that it might be appropriate to edit this language, and staff will address those concerns in its response comments to be filed next week. Next, with regard to the subsection 17.9.572.15i on cost recovery and elimination of the rider, staff maintains its position here as set forth in its initial comments. Specifically, staff's position is that to the extent that limiting the mechanisms for recovery of the reasonable costs of complying with the renewable portfolio standard to exclude rate riders is not contrary to the REA, then staff is not opposed to a transition from utilizing rate riders to utilizing base rates and or the FPPCAC for recovery of reasonable costs of complying with the RPS. However, staff does continue to believe that there are benefits associated with the use of riders. Those benefits include, but are not limited to, transparency, timely cost recovery, reduced carrying charges, and prevention of accumulation of RPS-related costs. If the commission does ultimately decide to eliminate the use of rate riders for RPS-related cost recovery, then staff recommends that Rule 530, which is the filing requirements in support of rate schedules for investor-owned utilities, also be amended to specifically allow for the RPS-related costs and to recognize the cost recovery standard of these costs under the Renewable Energy Act. In addition to that, staff is not opposed to OPL's and NM Area's recommendation that RPS riders be line loss adjusted if the commission does ultimately allow for the continued use of rate riders. Staff believes that this is consistent with cost causation principles. And next, with regard to subsection 17.9.572.22, A, B, C, and G. This is on the financial and other incentive provision. Staff continues to believe that these subsections of the proposed rule are consistent with subsection 6216-4D of the Renewable Energy Act. However, again, staff agrees with some of the concerns that were raised by other parties, and staff believes that it may be appropriate to provide some clarifying revised language, and staff will address those in its response comments to be filed next week. Thank you.
Thank you very much. Next, I see that NMAREA is represented, and could whoever speaks for them, could you identify yourself for the court reporter?
Hi, good afternoon. Can you hear me?
Yes.
This is Kelly Gould. I represent New Mexico Affordable Reliable Energy Alliance, also NM Area. Hold on, let me minimize my Zoom. So I will address three areas of the rule that we addressed in our comments that were recently filed. First, I would like to address section 17.9.572.7a, the definition of average annual levelized cost. I know that this formula has changed from prior draft rules, and I just wanted to clarify for the record and for the commission that NM Area agrees with this formula. In other prior comments, we disagreed with this formula, but after reading other commenters' responses and after doing further research, we do think it's correct to time discount the energy in the denominator of the average annual levelized cost calculation. And we believe that this formula is basically the industry standard. And so we think that that's consistent with the way that it's done in other jurisdictions and for other issues. So we agree with how the commission has it here in this portion of the rule. The second issue that we've discussed at great length through this docket and prior dockets, specifically 19-00296 and other comments that have been filed in this docket, is section 17.9.572.15I. It's NMRA's position that the statute allows for any and all rate making to be allowed for the recovery of renewable energy, and that to explicitly disallow rate riders in the rule is contrary to the statute. We don't think that it's appropriate. We also believe it will tie future commissions' hands, and that this determination should be done on a case-by-case basis, and it should not be done in a rulemaking. If we think it would be appropriate for the commission to want more information in the utilities RPS plan filings, and that the commission could ask for transition plans or for information regarding the benefits of riders, and they could ask for as much information as they need to determine if there are benefits of the rider. It's our position that there are benefits to the rider. However, we think that that is more of a litigated position that should be addressed in a docketed case and not in a rulemaking. And whatever language the commission would want to have in the rule for the utilities to make those arguments in their plan, we think that would be appropriate. But to just blanket say that rate riders are not allowed to recover RPS costs, we don't think is appropriate. If a utility decides to use a rider and the commission approves a rider, we think that rider should be line loss adjusted. We also believe that the riders need to be looked at in a deeper context to see if there's capacity values that are being recovered in the rider, and that those capacity values should be given different rate treatment than the energy values. Our last issue is that we address in our comments and that we've addressed at great lengths is how to ensure that voluntary program participants are treated in accordance with the statute. We have backed away from comments that we have made in the previous NOPR where we wanted a formula put in the rule, and instead now we do believe it's appropriate for the utilities to propose mechanisms in their plan, in their RPS plans, and that we can look at those mechanisms in those plans. But we do think that it's imperative that that's required by the utility, and that the commission do adopt mechanisms to address the voluntary program participants to ensure that they are not charged the RPS charges pursuant to subsection B of 62-16-7. And I think on that point, I just would like to point out that there is a typo in the draft rule in that citation of the statute for the voluntary program participant section. And it is, the correct section is 62-16-7. The way that it's cited currently in the draft rule, it says 62-17-7. So that's just a typo that needs to be corrected. And those are all of our comments at this point. Thank you for the opportunity to speak.
Thank you very much. Next, I see that El Paso Electric Company is represented, and whoever speaks for them, could you please identify yourself?
Yes, can you hear me?
Yes.
Okay. This is Jocelyn Barrett-Capon on behalf of El Paso Electric. I'm getting a little bit of feedback, but I think I can proceed. El Paso Electric just has a few comments, most of them in regards to ensuring that the rule is in.
I'm sorry, ma'am. Most of them in regards to?
Most of them in regards to ensuring that the rule is in alliance with the statute. The first is section 17.9.572.7 subsection lowercase a, the definition of financial incentive. Because section 62.16.4D of the REA does not limit financial incentive awards to circumstances that encourage behaviors or actions that would not have otherwise occurred, EPE recommends that language be removed from the proposed definition for consistency with the REA. So that change would be to remove the language in the definition that states that would not otherwise have occurred. In that same section, subsection lowercase b, the definition of average annual levelized cost. El Paso Electric does believe that the formula in this draft proposed rule is the correct formula. However, we do want to go on the record as stating that though we don't oppose using this formula, we do believe that it's not necessary to define average annual levelized cost, and it should simply refer to an industry standard LCOE calculation, which would allow some flexibility for each utility to provide calculations specific to each project based on their own variables. And then finally, in this section, subsection lowercase c, definition of procure or procurement. EPE recommends the addition of a provision to clarify that the definition of procure or procurement does not apply to agreements to purchase energy or capacity from a qualifying facility pursuant to section 17.9.570 NMAC. Additionally, EPE recommends the addition of a provision to clarify that the REA's competitive procurement process is not limited to the section 17.7.3 competitive solicitation process. So EPE is recommending adding two subsections 1 and 2, which reflect those two additions. Moving on to 17.9.572.10, which is the renewable portfolio standard. El Paso Electric believes that the commission's proposal to limit a public utilities REC ownership to, quote, excess net metered energy purchased by a public utility is contrary to the REA and should be deleted. Consequently, EPE proposes the deletion of paragraph 3 of subsection capital C of section 10 in its entirety in order to ensure consistency with the statute. Moving on to 17.9.572.12, requiring a utility to conduct a retroactive RCT analysis for each REA procurement. El Paso Electric believes that the proposed rules retroactive RCT analysis is also contrary to the REA, which the language of which plainly applies the RCT to new procurements. As such, El Paso Electric would recommend removing the term proposed from the definition. I'm sorry, removing the terms existing or proposed and just keeping it as proposed procurements in the definition. Moving on to 17.9.572.15 subsection capital I. This is an area in which we will address in much greater detail in our written response. However, EPE does not support the proposed language that would bar continued use of a rate rider to recover reasonable costs. And as such, our views on this are largely in line with staff's. Should the commission decide to adopt the proposed draft rule and language and eliminate the use of renewable energy riders, The commission should consider deferring transition away from the RPS rider until corresponding changes are made to the Rule 530 to specifically allow for RPS related costs and recognize the cost recovery standard under the REA for RPS related costs. And finally, section 17.9572.22, which is the financial incentive. EPE recommends deletion of the phrase "in the future," also to ensure consistency with the REA's financial incentive provision. El Paso Electric appreciates the opportunity to provide these comments, and anything that was not addressed here will be addressed specifically and in more detail in EPE's response comments. Thank you for the opportunity to talk.
Thank you very much. Next, I don't know if Zoe Lees is going to be speaking for Southwestern Public Service Company. She said she had some technical difficulties. Is there anyone else who can speak for SPS?
Judy, can you hear me? This is Zoe.
Oh, yeah. Yeah, I can hear you.
I have remedied those technical difficulties. Thank you for the opportunity to make comment today. This is Zoe Lees on behalf of Southwestern Public Service Company. Southwestern Public Service Company has filed extensive comments in this rulemaking docket, most recently on October 14th. And instead of summarizing all of the comments that we have stated therein, I will just clarify that SPS supports the definition of LCOE as stated in the rule, levelized cost of energy as stated in 17.9.572.7.a. That formula is different than the one stated in the May 11th, 2022 NOPR. However, we inadvertently cited the May 11th, 2022 NOPR in stating our support of that formula. I want to clarify that SPS supports the formula in the most recent NOPR and believes that that is in line with industry standard and is appropriate to, if you're going to have a formula, it's appropriate to use that one. Other than that, SPS reiterates all its positions as stated in the comments filed on October 14th. And we don't waive any future comments that we may make in regards to this proposed rule. Thank you for the opportunity.
Thank you, Zoe. And to speaking on behalf of SPS. Next, can we hear from the City of Las Cruces? I believe Anastasia Stevens is here. Can you identify yourself?
Thank you. This is Anastasia Stevens on behalf of the City of Las Cruces. Can you hear me?
Yes.
I really apologize about having to do this via phone versus Zoom, but I want to thank, on behalf of the city, I want to thank the Commission for persevering so long and hard in updating Rule 572 in this case and in case number 1900296 UT, and for continuing to make improvements to the rule at each step of the way. The 2019 REA amendments enacted in conjunction with the Energy Transition Act envision and compel a radical change in everybody's approach to renewable energy.
Excuse me, envision and if you could slow down a little bit.
And compel a radical change to everybody's approach to renewable energy. Everybody means the commission, the investor-owned utilities, customers, and other stakeholders. The Commission, in the course of these two proceedings, has recognized the depth and importance of those changes. The IOUs and some of the other commenters have not. They want to continue doing the same things the way they've done them, the same way for close to 2 decades. Doing so might be comfortable and familiar, but it's not consistent with the very widely amended new statute. The city has filed extensive comments and will not repeat them here unless asked. I hope you will not. Nor will the city respond here to the initial comments submitted by the other commenters. We will reserve that right to do so in writing. And I hope that we will make ourselves clear. At this point, I believe our positions remain the same, except that we're evaluating what the Attorney General had to say about the annual levelized cost of energy calculations. As you know, the city's comments have focused largely on issues that we've raised in past litigated cases, the DG Rex and phasing out RPS cost riders. We believe that the law is very clear about this new statute and the fact that the statute has been changed first in case 0050035 to authorize the use of DG Rex associated with energy consumed on site. And then when that language was removed and other changes were made to the REA in 2019 to eliminate that option. And just for a sense of scale, El Paso Electric Company, which probably is the outlier here, about 25% of their total RECs in 2021 were associated with DG energy not purchased by the utility. That is DG energy consumed by the customer. That's a really substantial portion, and that portion does not get calculated. There's a double hit because that portion does not show up when the utility calculates its overall RPS requirement because it's not energy consumed on the denominator side. It's not energy that they consider to be retail sales. So there's a double hit there. I will elaborate on that in the response comments, but the city believes it's quite clear, and that we really appreciate that the commission has recognized that as this process has gone forward, and we have proposed some slightly clarifying language. Likewise, we believe that the commission is doing the absolutely right thing to eliminate RPS cost riders in multiple comments in this case and the last one. It's clear that the existing RPS riders of each of the utilities are very widely, don't represent anything in particular, and don't comply with the intent and the needs of the current RPS Renewable Energy Act. They're a vestige of a long ago past in which renewable energy acquisitions were a minor portion of the utilities portfolio and were inordinately expensive. With that, I'll stop speaking. I just want to thank the commission again for carrying forth with great effort to make this very necessary transition to the renewable transformation that the legislature has mandated, that the city of Las Cruces has supported even before the legislature went there, and it's for the best of all the citizens of New Mexico and the customers of El Paso Electric Company. Thank you very much.
Thank you very much. Next, I see that PNM is present, and who would like to speak on behalf of PNM?
Good afternoon. My name is Samantha Kelly. I'm here on behalf of PNM. Leslie Padilla is also on the line, as is Steve Schwebke. And I just wanted to note first that we have also submitted written initial comments on October 14th. and plan to file whatever we need to in response comments and also in written reply comments. Just as a very quick summary of our comments filed on October 14th, PNM generally does not oppose the definition of the average annual levelized costs formula as long as it remains in the RCT calculation. The bulk of our comments address section 572.15I, which proposes eliminating the rate rider. For many of the reasons already stated here today, PNM opposes the elimination of the rider. For some of the reasons noted by staff as well, it lowers costs to customers, it provides transparency, and it allows utilities to timely recover their costs. And finally, our comments also address section 572.22, addressing financial incentives. We note that this section is the subject of an appeal at the Supreme Court, and we generally oppose the limitation of an incentive to conduct by the facility that occurs.
I'm sorry, we generally oppose the limitation.
The limitation of the incentive to conduct that occurs in the future, which is a comment also noted by EPE today. And otherwise, we would like to reserve the rest of our comments for our written response and reply comments, and appreciate the opportunity to talk today. Thank you.
Thank you. I see that Joan Drake is present. Would you like to make any comments? I assume, are you here on behalf of, please, I guess at this point, state who you are here on behalf of.
Thanks, Judy. Hi, good afternoon, all. This is Joan Drake. I'm appearing in this hearing for Louisiana Energy Services, or LES, excuse me, which is a large industrial customer of Southwestern Public Service Company. LES did not submit written comments most recently in this case, but I would know we did provide comments in written form on January 18th and on March 2nd in this case, and we do intend to provide comments next week in response to the initial comments that were filed last week, I believe. So I'll be brief here. I think that LES is generally in accord with New Mexico Large Customer Group and Occidental, as we are similarly situated and so on. So I will keep my comment short here and just note that we will provide our responses in writing next week. Thank you.
Thank you very much. I'm not sure if someone is present from Occidental. I know that Occidental Petroleum Limited did file comments on October 14th. Is there anyone present?
Yes, hello. Michael McMillan for Occidental.
Thank you. Do you have any comments?
Yeah, so briefly, Occidental filed filed written comments on the prior version of this NOPR, and we submitted slightly modified written comments in response to the current version. And I wanted to point out the way in which our most recent set of comments was different. So specifically, we addressed the changes to section 572.22C. And as drafted in this notice of proposed rulemaking, that section reads, "A public utility shall not be eligible to receive a financial or other incentive for the production or acquisition of renewable energy or RECs prior to the date that the public utility files an application with the Commission for approval of a financial or other incentive." So I believe that the intention here, and I lay this out in our written comments, I believe that the intention here is to ensure that the financial incentives are forward-looking, that they're actually encouraging utilities, as in the definition of a financial incentive, to do things that they would not have otherwise done. But as in our written comments, it's possible to read that language as saying that the eligibility to receive a financial incentive begins on the date the public utility files their application. And to just read that as a requirement to file an application as a prerequisite to get a financial incentive. And in our comments, I lay out a pretty easy change, just moving one clause of that section that resolves that potential misunderstanding and could prevent us from litigating that in the future. So as far as public comment, that's all that I had. I just wanted to point out the one primary difference between our prior written position and our current written position. And you know, we do plan on filing reply comments in the coming weeks. So you know, look forward to continuing to participate. Thank you.
Thank you. New Mexico Large Customer Group, I believe, is present. Who would like to make comments on behalf of New Mexico Large Customer Group?
Good afternoon, Judy. Nick Stoffel here for the NMLCG. Good afternoon, Chairman Fishman, parties. So the NMLCG has been filing comments in this proceeding over the last couple of years, including as recently as on the 14th. And I don't want to rehash those. Generally, we addressed the elimination of the RPS riders, and based on our comments, we support that. I'll say we do recognize the issue that's been raised about how to ensure that customers taking service under voluntary renewable programs aren't being charged for RPS costs for the energy provided under those programs. And so we do see that as an issue that the commission should at least provide an exception for, or at least a path to accommodating to make sure that customers aren't being essentially double charged for renewables under the various rates. So we think putting the utilities on a trajectory to eliminate the RPS riders while accommodating that need to allow for voluntary programs is important. The other issue we specifically addressed in our written comments has to do with Rule 572.22 in the financial incentives. We proposed some wordsmithing changes, I think largely like what you just heard from Occidental, trying to clarify the rule and minimize disputes about the rule in the future. And then also there's been this discussion about should the rule permit incentives for past conduct, which really to me defies the definition of incentive and what an incentive is intended to do. But I think more importantly, the commission should keep in mind that a rule that provides for incentives prospectively does nothing to take away any incentives that may have been approved under prior versions of the Renewable Energy Act or prior versions of the rule. So not only does the rule say as of the time it's effective, it's applying prospectively, there is nothing in that rule that takes anything away that the commission has previously granted utilities. And so we think that's an important point for you to keep in mind as you look at that language and evaluate the arguments about whether or not past conduct should be accommodated under that rule. Other than that, I'm here this afternoon to answer questions. Appreciate the opportunity to provide these oral comments.
Thank you very much. Is anyone present from the New Mexico Attorney General? Hearing none, I would ask then, would anyone else like to make any public comment that I haven't recognized? Well, hearing nothing, I would request Commissioner Fishman to make any comments if he would choose to at this time.
Yeah, Judy, just for everyone, there's a couple issues that in my decision making I'd like more clarity on as comments are submitted. So one of those would be regarding the renewable energy rider. I'm frequently hearing the argument that doing the rider eliminates carrying costs and saves customers money. And I'm having a little trouble processing that one because what seems to be happening in practice is that if it's a PPA, the costs are getting charged as a PPA pretty much immediately, and most of the assets currently are PPAs. And when it's not a PPA, it seems that filings are not under the REA. They're under our general procurement rules, in which case it is added to rate base and the utility does get the profits. So I have a really hard time understanding, given the way that utilities are currently acting under the current rule. I'm having difficulty processing how this rider saves consumers money in any way. The second big issue is, given the trajectory of renewables, I'd like more clarity around how we address the issue of if so many of these assets, presumably if they're owned in particular, are going to fall under the rider. It's going to look really strange on a customer's bill to see that 50 or 60% of their bill is a renewable rider, as more and more assets are going to move that way. And I don't believe that informs anyone of anything. I don't believe it's particularly helpful. And the third big issue for me is, I know people, I've heard the argument that cost, that from one utility, that the cost of renewable rider, that projects that would go under the REA would only be projects that are more expensive than would have been if there hadn't been an REA. So that therefore the rider only captures excess costs. And as I look going forward at the impacts of various generation decisions on a system-wide basis, meaning including transmission and distribution, what the full costs are becomes a very subjective proposition. And I would like to see more clarity about why these cost projections that are limited only to the specific project aren't so limited that they really aren't meaningful, and that the information that this rider theoretically provides really doesn't represent any viable decision-making information. So in terms of those who oppose elimination of the rider, I think it's really important for you guys to marshal some more clear arguments addressing those three issues. And I'm sorry if I was a little bit unclear in presenting them, but feel free to ask questions if that's how you feel. Finally, on the renewable energy rider, on the double charge issue, I kind of grasp what people are saying about that. I'm not sure I do fully. So I'd certainly appreciate in the comments that come forward, any more clarity that people can lend to that issue to be sure that we're handling that one correctly. And with that, I'll shut up.
Well, thank you very much, Commissioner Fishman. Would anyone like to respond to anything Commissioner Fishman said, or before I close the public hearing?
Judy, this is Robert with Commissioner Fishman's office. I don't have a response for my boss, but I do have a few comments to make.
Okay, that would be excellent.
Sure, yeah. So for all the commenters here today, it would be very helpful if in your response and reply comments, if you could address the proposed changes by the New Mexico Attorney General's Office and OPL regarding the average annual levelized cost definition. From what I've worked through so far, those are the two parties that have kind of proposed some word changes to the definition itself, and it would be good to hear the responses of the others. Additionally, I would ask if Kelly Gould from NM area could maybe elaborate more on one issue that she addressed in NM area's comments, and it relates to the voluntary program customers. In our proposed rule, we kind of have this transition plan idea, and we asked the utilities to propose a mechanism to make sure that voluntary program customers are kind of held harmless from these double charges or overcharging from RPS costs. But NM area in PNM's recent RPS case and in this case has sort of lightly raised the issue of, well, if there's costs of RPS assets in the FPPCAC currently and in base rates currently, are these voluntary program customers being protected currently? And do we need this mechanism to kind of apply more broadly? So if Kelly Gould wishes to elaborate more on that now, that'd be great. If not, I would just ask that she does in response or reply comments. Thank you.
I'm sorry, sir. Can you state your last name, please?
Yeah, this is Robert Lundeen, and I work with the commission.
Thank you, sir.
Yes, and for the record, I'd like to state the participants, since we don't have an actual sign-in sheet. It's myself, Judith Amer, Robert Lundeen, David Lee, the court reporter, Commissioner Stephen Fishman, David Black, and Alicia Leba Tessera from Utility Division staff, Jim Schichtel, I believe from El Paso Electric, Joan Drake from LES, Jocelyn Barrett Capin, I'm not sure who she represents, Kelly Gould.
I represent El Paso Electric.
Okay, thank you.
You're welcome.
Kelly Gould representing NMAREA, Leslie Padilla representing PNM, Michael McMillan representing OPL, Nick Stoffel representing New Mexico Large Customer Group, Samantha Kelly, I believe representing PNM, Steve Schwepke representing PNM, and Zoe Lees representing SPS. And hopefully that's all that I see present. I don't want to put Kelly Gould on the spot. If she would like to respond now, this would be the time. So please let me know.
Sure, yeah, thank you. This is Kelly Gould with NM Area. I will address Mr. Lundeen's question in our response comments, but just to briefly address the issue here, we raised in PNM's latest RPS plan case 22-001143, the issue of recovering costs for renewable resources through the fuel clause while counting those RECs as RPS compliance, but not attributing any value to that compliance. And we are in, so I will say that it's a complicated issue and it is changing. I think that this is something that we're all struggling or trying to address as we move forward, and we can see it in these comments and with the tension of whether or not to keep the rider or reduce the rider, get rid of the rider. I think that currently PNM and all the other utilities are at 20% RPS required by statute, and as we move forward with the ETA and the REA, the percentage of RPS continues to grow. And so we are encountering new and different issues. And this is one of them. When the statute was amended, it allowed for these voluntary program participants to be excluded from RPS costs. And in exchange for that, the voluntary program participants load is not included in the calculation which determines RPS compliance. So basically they're just taken out of the equation. Having a rider makes it much simpler because those voluntary program participants are not charged the rider or a percentage of the rider. Currently, there's very little, at least in PNM service territory, there's very little resources that is recovered through base rates that are considered RPS resources. However, in 2023, new resources, new PPAs will be coming online, and those PPAs will be recovered through the fuel clause. It's NMArea's litigated position that those PPAs should actually, the cost of those should actually be recovered through the RPS rider and not the fuel clause to make this accounting simpler. However, as long as there's some accounting mechanism that's provided for by the utility where it's recovered is really not as big of an issue for my client, but we are trying to simplify the issue. And we think the simplest way and the clearest way for my clients and other customers is to have all the RPS compliance costs in the RPS rider. I think that to Commissioner Fishman's point, regardless of whether the RPS rider is large or the fuel clause is large, there's going to be large riders on the bill as we move forward to 80% renewable energy, because if those PPAs are not allowed to be recovered through the RPS rider, because if the commission decides to not allow an RPS rider, they will be recovered through the fuel clause. And so still the customer is going to have a very large, that is going to be a very large portion of the customer's bill. And I think that creates other issues and confusion because PPAs aren't really fuel. I think that seems confusing to customers also. So I think that the issue is larger than just getting rid of the rider. I think it's great to get more information from the utilities in their next plan, and to have the utilities provide testimony as to the benefits of the rider and make these decisions on a case-by-case basis. It is our opinion and our expert witnesses' opinion that the RPS rider does save customers money. And so to do away with the rider, we think is not in the overall customer's best interest. But I think that if each specific utility needs to prove that up in their RPS plan, that they should do that rather than just have a blanket statement of getting rid of the rider. So currently, I would say that there's just a very small portion of RPS compliance that's not being accounted for in the rider, and so it hasn't really been an issue for voluntary program participants. However, coming in 2023, there will be new resources that will be recovered through the fuel clause. And we think that the issue just really needs to be looked at. We are not sure if there's an issue there or not, because we don't know how that interaction with the fuel clause is going to play out when those resources are recovered in the fuel clause. We are also in talks with the utility to see if we can come up with, like I said, this is kind of uncharted territory. So looking at other jurisdictions, if there are any, of how they've encountered these issues, and really just looking at, it's a really complicated issue, right? Because if a renewable energy resource charges a battery and then that battery is deployed for system benefit, we don't think that the voluntary program participant shouldn't pay for that piece of energy, right? And so how the energy is being used and whether it's a system resource or RPS resource, we think is complicated. It's not as clear as it used to be. And so what we're advocating for is to get rid of those kind of box definitions and come up with an idea to think about what is RPS compliance and what is the value of that, and looking to the spirit of the statute, which is if you have renewables under a voluntary program, that you are not also charged for these renewables that are for the RPS compliance. And again, it's going to have to be an evolving mechanism as we move towards 2040, because as the utility continues to increase its voluntary renewable penetration, as it continues to go to 80%, the voluntary program participants are going to not have such a big piece to their program, right? Because really the statute allowed for these voluntary program participants to be on the leading edge. It's for these customers that want to have more renewable energy than what is required by the statute. And so as PNM and other utilities continue to increase their renewable load penetration, the purpose and the intent of the voluntary program is going to diminish, right? And so it's kind of just like we're in this transition phase, which we all know we're trying to address issues which are complicated, and we're trying to do it in the best way possible. And so I think that's why NM area has backed away of having a mechanism or a definition for this specific issue with the voluntary program participants in the rule. And we think that the best way forward is to have the utilities propose mechanisms to address this issue and to start really thinking about RPS compliance in a different way that we have in the past. And I don't know if that answers the question or creates more questions. We've briefed this issue pretty extensively in PNM's RPS case, and we also filed expert witness testimony in that case. And we do look forward to work with the utility before their next RPS filing to see if, we can address this issue in a way that we think complies with the statute. Thank you.
Judy?
Yes.
If I may,
Kristen, yes, thank you.
Kelly, thanks for those comments, and thanks for kind of just doing it on the spot here. So again, just on the idea of the rider saves folks money, perhaps I haven't understood the argument that's been made, but I think as we move forward, if you want to convince me on it, it's worth readdressing that and trying to clarify that argument so that if I'm missing something, it can get through my thick skull. And so I just wanted to give you a heads up and let you know what I need to hear rather than just leave you in the dark.
Yes, we'll attempt to address it again in our next upcoming comments. I think that the utilities have attempted to address it. And I think, again, the issue is somewhat complicated. And it probably also depends on the way that you read the statute. But at least from our perspective, the way that NM area reads the statute is that all renewable energy shall be recovered. And it's treated differently than the way that other resources have been treated in the past. And so I think that there's a concept that it's not really like, coal-fired generation that is recovered through base rates. And if the utility recovers it, great. And if they don't recover it, too bad. And so that there would have to be some kind of accounting mechanisms which would have carrying costs. There's other issues in which the utilities address, which they allow for depreciations of those assets through the rider. So the customers receive the benefit of those depreciating assets in real time, which we think is important, especially because at least in PNM service territory, they have not been filing rate cases very often. And so if customers would have to wait for 5 or 6 years between rate cases to receive those benefits, we think that that's a detriment. And there's other issues which I can address, and I think that they've been touched on in other comments, but those are two that come to the top of my head. Thank you.
Okay, thank you.
Well, thank you very much, everyone. If no one else has any questions, I would say that the public hearing in this matter is concluded, and it is 2:07 p.m. Thank you.
Judy.
Thank you,
Thank you.
Judy.
Thank
Bye.
you.
Thank you.